Hello everyone, thank you for watching this video. In today's video, I will be discussing the most anticipated topic, alternative dispute resolution. According to the Civil Procedure Rules and the Pre-Action Protocol, all parties should always try to settle where they can and to avoid going to court. I will be looking at, firstly, what is ADR? Secondly, the four main types of alternative dispute resolution. Thirdly, the advantages and disadvantages of the different types of alternative dispute resolution. Please continue to like, share and subscribe to my channel. Also, comment down below what types of videos or topics you would like me to cover next. What is alternative dispute resolution? Alternative dispute resolution derives from practice direction and the civil procedure rules. The aim and spirit of the civil procedure rules is to resolve disputes as cheaply and as quickly as possible. Parties should exchange information, consider alternative dispute resolution, and attempt to resolve issues without beginning proceedings. Therefore, as I said in my introduction, all parties should always try to settle where they can. Courts are very keen on encouraging parties towards ADR before pursuing litigation. Always explain the various types of ADR to your client. This is very important, and identify the circumstances where ADR may be preferable to litigation. So, in a nutshell, simply, ADR are alternative ways to settle a dispute rather than going to court. There are four main types of alternative dispute resolution. Or we can say there are three main types of alternative dispute resolution. The first type is mediation. Mediation is a structured, interactive process where an impartial third party helps the disputing parties to resolve a dispute. Negotiation is the second type of ADR. This is a dialogue between two or more parties in an effort to resolve a dispute. And thirdly, we have arbitration. Arbitration is a private meeting when an independent arbitrator helps to resolve the dispute between the parties. And fourthly, we have litigation. Litigation is where a party issue proceedings in a court of law in order to resolve the dispute. Now, the three main types of ADR is mediation, negotiation, and arbitration. Litigation is where none of three ADR has been successful, then a party will decide to go to court. We will now look at the advantages and disadvantages of negotiation. Advantages: there is minimal cost to negotiation, it's quicker, it's not binding, it is flexible, it's private and confidential, it encourages informal discussions, and it preserves business relationship. However, there are disadvantages such as settlement may not be achieved between the parties, and there may be complexity in the type of issues that is to be discussed in the negotiation. Okay, so therefore, negotiation may not be the best ADR for the parties. In cases where negotiation is not the best option for parties to settle their dispute, The parties can have a think and can have a try at mediation. Advantages of mediation is a neutral third party who is called a mediator. It's low cost, it's relatively quick, it's not binding, it's very flexible, it's private and confidential, and it preserves relationship. The downside or the disadvantages to mediation is that settlement may not be achieved and there may be complexity in the issues. Where mediation or negotiation is not the best alternative dispute resolution, to resolve the matter between the parties can try arbitration. The advantages of arbitration is it's a private forum with an arbitrator. It is cheaper, faster, it is binding, and it is enforceable. It is very flexible and it is private and confidential. However, the disadvantages are there are fewer remedies available with arbitration. It can be slow and it can be expensive. Where parties fail to settle via an alternative dispute resolution, the parties can try litigation. The advantages of litigation is there are more remedies available to the parties and it can cover complex issues. However, the disadvantages, it's an in court, it is expensive, it can be slow, judgment is binding and enforceable, there's no flexibility, and it is open to the public. Thank you for watching this video. Please like, share and subscribe for more videos.